Okay, hello everyone. Thank you very much for attending the second eSeminar in our series, Contemporary Debates on Peacebuilding and Statebuilding. My name is Jeff from the Center for Security Governance, and I'll be giving you a quick technical intro of how you can interact through Spreecast. Some of you have already started to use our live text chat, so please continue to use the chat and use it to ask questions of our panelists throughout the event. If you have any questions or experience any technical issues, feel free to email me at this address, and I'll try and work on the issue as quickly as possible. At this point, I'll pass the floor to Dr. Andrew Thompson from the Balsillie School of International Affairs to make some introductory remarks. Andrew?
Hi, everyone. First off, thank you for joining us. I think we've got a terrific panel today. And the issue of resource extraction and peace building, I think, is incredibly important, and in fact, is one of the burning issues in the field of peace building today. And it's one of these issues that touches on the full range of human rights. It deals with political and civil rights. It deals with economic, social, and cultural rights, question of group rights, and I think it's something that as humanity we're going to have to deal with for the foreseeable future, and it's one of these issues where there really is a lot of solutions to the problem. So like I said, we've got a terrific panel today. We've got a nice mix of practitioners and an academic. We have Tara Skur from Amnesty International Canada, who's going to talk about the Latin American context, and specifically about some recent work that she was involved with in documenting some human rights violations in Guatemala around the extractive sector there. We have Dr. Terry Mitchell, who's an associate professor at Wilfrid Laurier University and a colleague of mine at the Balsillie School of International Affairs. And she's going to be talking about how this issue affects Indigenous populations. And she'll be speaking a little bit to the Canadian context as well as the UN Declaration on the Rights of Indigenous Peoples, which is really the key treaty that can help govern some of these disputes. And finally, we have Bernard Taylor of Partnership Africa Canada, who will speak to the African context. And for those of you who may not be familiar with Partnership Africa Canada, it was the first organization to draw attention to the issue of blood diamonds. And so we're very excited to have Bernard and Tara and Terry. And so the way it will work is that each panelist will speak for about 10 to 12 minutes. And I've asked them to say a little bit about their organization and how they came to be involved with issues of extraction and conflict. They'll then talk a little bit about very specific cases that they're working on. And finally, I've asked them to talk about some of the remedies that are being pursued, some of the governance solutions that people are working to help bring some resolution to this issue. So after each panelist has spoken for about 10 to 12 minutes, we'll open up the floor to questions for about another half hour, and then we'll do a little wrap up. So without further ado, I will pass things over to Tara.
Everyone hear me okay? I'm assuming that's a thumbs up. Okay, I'm going to assume that you can all hear me okay, and thank you very much for inviting me to the panel. I'm going to refer to some notes that I have here to keep myself on track. So just by way of introduction to Amnesty International, for those who aren't familiar, Amnesty International is a global movement. It was established in 1961 in the UK. There are currently about 7 million members to the organization, and our goal is to conduct research and generate action to prevent and end grave human rights abuses and to help victims of those abuses seek justice. So some of you may be familiar with Amnesty because of our work around the death penalty. But since then, since the early 90s, that work has grown to also consider the impacts of economic globalization on human rights. And one of the emblematic cases with regard to business and human rights that we first got involved in the 90s was the case of Shell Oil in the Niger Delta, and the Ken Saro-Wiwa and the Ogoni case. And so our work around business and human rights dates back to that time. In Canada, we've worked on corporate accountability and business and human rights issues for about a decade. And part of the reason for that, or I guess the overriding reason for that, is that between 2/3 and 3/4 of the global capital raised for extractive industries is raised in Canada, and over 50% of mining corporations are headquartered in Canada. So some industry research that was commissioned a few years ago to look into accounts of human rights violations in the context of extractive industries revealed that the majority of those human rights violations along a spectrum were taking place in the context of Canadian mines. And so we have a very concrete reason for establishing our business and human rights program. And so my particular area of focus, as Andrew mentioned, is at Latin America, more specifically Central America, and looking at the activities of Canadian mining companies primarily, looking at investment issues and access to remedy for victims of human rights violations. I'm not a lawyer, I'll just say that up front. But what I'd like to talk about specifically today is the extractive sector in Guatemala, and which we think is emblematic of the problems that we're identifying, and talk a bit about our findings and the struggle for justice in Guatemala. And I'm going to try and do this in 10 minutes. So I just want to give a little bit of a framework to this in the context of some of the international instruments that we're working on and supporting. So just to, I'm sure many of you will be familiar that in 2001, the Human Rights Council passed the UN Guiding Principles on Business and Human Rights, basically to provide guidance for companies and states regarding corporate activity. And so the UNGPs established the roles of companies and states with regard to human rights and remedies. So state duty to protect human rights and corporate responsibility to respect human rights. And then some guidance around how to remedy abuses when they occur. And so we've seen this as a positive step forward, a positive contribution. And we've seen many of the larger companies adopt the UNGPs or refer to the UNGPs in their human rights policies, for example. But we've seen very little progress on the ground in places like Guatemala, or places where there are serious conflicts between communities and companies, and where the state is either playing an active role in perpetuating the conflict or is absent and has a very weak regulatory structure. So out of the UNGPs, countries or states were asked to develop national action plans for implementing the guiding principles, but unfortunately Canada lags quite far behind. And so Amnesty's goal within business and human rights has always been to establish mandatory human rights standards for companies. And currently we have kind of a menu of a variety of voluntary standards, and there are some incentives for good corporate behavior. Canada has a policy. It's called what's it called? Seeking the Canadian Advantage. So essentially all diplomatic resources are funneled into building support for Canadian companies overseas, but very little guidance or mandatory rules around respect for human rights. We think this is a problem. This is something that we are working on. We believe Canada needs mandatory human rights standards. And so the Guatemala case study is one way to help move that conversation along. And it's important to note that in Canada, there are currently 4 civil lawsuits against Canadian companies trying to establish that these companies owe a duty of care to people living in communities around their operations. There are there's one case against Nevsun for its operations in Eritrea, and there are actually, 4 cases involving 2 Canadian companies in Guatemala. So we can maybe talk about that a bit later, but just so that you're aware that the lack of guidance, the lack of regulation for the activities of Canadian companies overseas, the context that they're operating in, has resulted in a number of lawsuits being launched in Canada and victims seeking justice here in Canada. We hope they're successful. So in the case of Guatemala, Amnesty began investigating human rights concerns linked to a Canadian mine in the Western Highlands. This was Goldcorp's Marlin mine, which was the first major development project in the country in about 20 years. And in 2011, we sent our first research mission to Guatemala to investigate the impacts of extractive industries on human rights, and in particular on Indigenous rights. And so I'll just list a few of our key findings for you. We found that opposition to mining in Guatemala is widespread and persistent. It has engendered high levels of conflict. The concerns that communities raise are lack of consultation or meaningful consultation about the risks and the benefits of a mine. So often there will be some community meetings as part of an environmental impact process. And the benefits of the mine will be discussed. You'll have schools, you'll have roads, you'll have development, you'll have jobs, but the potential negative impacts are brushed off. And we've seen transcripts of some of these meetings where a farmer will say, I'm a farmer, I rely on the water, I rely on good soil, I'm really concerned about contamination. And the response either from the company or the Ministry of Energy and Mines representative will be, there will be jobs, don't worry, you can trust us. And that is not the appropriate level of information being disclosed for people to make a good decision about whether or not they support a mine. And so this lack of meaningful consultation, lack of meaningful information about the risks as well as the benefits, and a chance to really collectively establish mitigation measures to deal with those risks, that hasn't happened. And so we've seen in the last 10 years now, a number of consultations that have been carried out by communities under the Municipal Act, in which over 1 million people across Guatemala have participated and responded to variations on the question, do you support mining in your community? And somewhere between 98 and 99% of respondents have said no, yet mining continues. Just to go back to a couple of the other things that people have highlighted as concerns, long-term environmental impacts, effects on livelihoods. As you can imagine, many of these mines take place in agricultural areas. We met one farmer who told us that he sells to a middleman who purchases for Walmart. Walmart said that they are very concerned about the impacts of a mine in this particular area and that they would no longer be buying produce from this area. We couldn't get it in writing, unfortunately, but these are the kinds of stories that farmers are telling us. We also found in Guatemala that the regulation governing the extractive industries is quite weak, particularly in the areas of consultation and the need to seek the consent of Indigenous peoples. We found that companies are mostly meeting these poor national requirements, but they're not meeting international standards for best practices. They could be doing better. The UNGPs have outlined that meeting the letter of the law is not enough because often those laws in countries where companies are operating are inadequate. And on the other side, companies are being left to their own devices to manage very complex consultation processes in a post-war context. But the result has been very serious human rights violations and incredible impunity and a very uneven application of the law. I was going to refer to a number of cases dating back to the 60s, but I think I'll skip over that right now just in the interest of time. But important to mention that in a case that has roots in Canada, from the 60s, the case of the Inco nickel mine in eastern Guatemala, has repercussions today. That mining license was granted in the 60s. The Maya Kekchi people were moved off their land. The company was found by the UN to be complicit in a number of arbitrary executions. And but that mining license has been renewed, and there has been a series of Canadian companies involved in that mine site, resulting in 2007 and 2009 in the attempts to forcibly evict people who had moved back onto the land, from the land, to be able to restart the mine. There are now 3 cases that are being heard in Ontario as one lawsuit against Hudbay Resources, which was the last Canadian operator of that project, for the gang rapes of 11 women, the shooting and injuring of a young man, and the killing of a community leader, Adolfo Ish Shaman. His widow, Adolfo's widow, is currently in Canada on a speaking tour. She's in BC to share their story and to talk about the lawsuit that they have in Ontario. So there has been, since 2005, when the Marlin mine was established, I guess you could say the Marlin mine was established in a very conflictive context, because in 2005 the company was attempting to move massive mining equipment up the Pan American Highway to the mine site, and there was a protest that started and lasted for about 40 days and ended with the killing of a protester, Raul Castro Bocel, and the injuries of many others. And at the time, then President Oscar Berger said, as perhaps a justification, well, we have to protect investors. And that is a story that has continued to this day in Guatemala. In 2014, the UN Special Rapporteur on Human Rights Defenders issued a report saying that human rights defenders operating in the context of extractive industries and major development projects are some of the most at-risk defenders in the world, and cited Guatemala as one of the 6 countries which her office received the most communication from. So we have seen threats, attacks, shootings, rapes, and killings of people involved in opposing mining operations. And we've seen public and private security forces involved in those attacks. And so one of the other issues that we identified in our research related to some of these attacks is that often small grievances or issues that could have been resolved, could have been dealt with by the company or by the government, were ignored, and were allowed to fester into much larger concerns, and then became public security issues, and a very heavy-handed response ensued. And so, you know, impunity, people talk about impunity in Guatemala. There is impunity for, I mean, you couldn't write a movie or a book, a fiction that is as horrifying as I think the reality in Guatemala for victims of human rights violations over the last 40 years. About 1 in 5 murder cases in the country are investigated. So within this context, people know very well that if they're a human rights defender and they're attacked, they're very unlikely to see justice. And we have quite a few human rights defenders who have been living with armed protection under precautionary measures issued by the Inter-American Human Rights Commission, for example, for years, knowing that their cases are not going anywhere. And I mentioned earlier, we've seen a very uneven application of the law. And so I'll give you an example. In 2013, the Guatemalan state ordered a state of siege, which is kind of like a state of emergency, we would call here, in a community. Civil rights were suspended for 30 days and because of a number of conflicts related to criminal activity in the area, but conflated with some of the anti-mining protests, in which 7 people had been shot the week before. So when the police and military moved in, activists' homes were searched, and a number of activists were held in maximum security prison for months and let go eventually without charges. But the company contractor, the head of security for the mining company, who ordered the shooting of ordered the shooting of protesters, he was allowed to stay under house arrest in the mine site in his home. So that's a kind of a glaring recent example of the different ways that human rights defenders and activists are treated compared to companies. I'm just wondering how many more minutes I may have here, just so I can wrap up. Or am I overtime?
Yeah, no, I think you're a little over time.
Dang. Okay.
We'll come back for questions.
Okay. Shall I just end it there?
Yeah, why don't we go to Terry, and I'm sure there will be a ton of questions for you, Tara. So our next speaker is Dr. Terry Mitchell, and she's an associate professor at Wilfrid Laurier University, and has been working on the rights of Indigenous peoples, and specifically how it relates to the UN Declaration on the Rights of Indigenous Peoples, which I think is a really good segue or a follow-up to our last presentation. So over to you, Terry.
Hi, thanks, Andrew. And thanks, Tara, for that gut-wrenching orientation to the issues that I'm going to speak about today. So I was wanting to ask the question related to this series, is peace possible? And I want to talk about the context for peace and for coexistence amongst Indigenous peoples and settlers, and in the context of resource extraction and the terrible human rights violations that are occurring as characterized by Amnesty International and Tara's speaking. So I have some notes, and Andrew, please let me know when I'm finished here with my time, because I will go on and on and on. But I would like to say that I'd like to speak about possibilities and about the incredible importance of leadership and participation of Indigenous peoples within Canada and worldwide right now, to talk about an exceptional moment in history when, while we have gross and perhaps increasing human rights violations with the global corporate economy, we also have in parallel the development of an emerging international human rights regime for Indigenous peoples and by Indigenous peoples. So I will talk in brief about the United Nations Declaration on the Rights of Indigenous Peoples and its importance in this dialogue, that it not be just a declaration and a document, but an agreement that we hold together as world citizens. So in that regard, I'd like to speak about the opportunity for what Indigenous leaders have called self-determined development. And I would talk about that as rights-based development and work towards the concept of self-determined sustainable development. Self-determined sustainable development would require the participation, the legitimate, authoritative participation of Indigenous peoples in the control and consent of what happens on their lands, and for their own image and vision of development, or as some would say in Latin America, concepts of buen vivir, which can be in contradiction to classical Western concepts of development. So I'll get more to that. So is peace possible? Can we move from what's characterized in Canada for over 100 years as the Indian problem to an understanding of Indigenous privilege and Indigenous power within the context of an emerging international human rights regime? I will touch back on some of the opportunities and possibilities as Tara framed around the global principles of that Ruggie helped define for the UN on to protect, to respect, and to remedy. The protection was meant to be governments protecting communities from industry. Industry respecting the rights through corporate social responsibility of Indigenous communities, and the remedy of ecological and cultural economic issues that have come through industry. However, what we'll see is that industry is in many cases ahead of where government is in terms of resource extraction, and the principles of respect and protection in relation to the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP, in terms of the principles of free, prior, and informed consent. So we need, I'm going to end my talk by suggesting that we need not only the UNDRIP and the UN principles and Indigenous leadership and corporate responsibility, but we need a transnational global governance mechanism to ensure that there's compliance with UNDRIP. Because at this point, the Canadian government, for example, says that UNDRIP is only an aspirational document, and they have blocked in nationally and internationally discussions about free, prior, and informed consent. And in fact, as recent as this last fall, the World Council of Indigenous Peoples said that they would not support the outcome document of the World Council, which called for compliance of nation states with UNDRIP and with free, prior, and informed consent, as you can imagine, in relation to development and resource extractive industries. They, in fact, the Canadian government put out our own document saying that Indigenous people should not have veto power, that UNDRIP was suggesting veto power, i.e. that we should remove consent from the notion of consultation. So that's a longer discussion. So back to the question of, is peace possible? I think that I know that there's an unprecedented demand, a global demand for resources and investments in the extractive industries. And as featured by Tara's talk, in just one region, globally we have these ongoing challenges of human rights violations, of compromising of territories and environments. And this is in direct contradiction to the very principles of the identity and identification definition of what it means to be Indigenous. To be Indigenous means to be a steward of one's land and to have the right to live in and enjoy the environment. So we have on one hand the unprecedented impact of global industry and a thirst or a hunger, a demand for a global economy premised on resource extraction. At the same time, we have a growing Indigenous population and increasing global communication between the 360 or 70 million Indigenous peoples worldwide, as well as the emerging Indigenous rights regime. This has not stopped the occupation of lands and territories and the ongoing mining, but we see that there's a different context than there has been in the last round of colonialization and the last historical round of land takeovers and occupations of Indigenous lands. We had a different world order, and we didn't have the threat of global corporations. We had countries coming in and attacking and taking over lands. But now we have companies coming in a different situation. So what we see is increasing amounts of conflict in more and more territories around the world. We see conflict that results in we have not seen great demonstration of increased wealth and schools and roads and health benefits for Indigenous peoples. We have seen overall, within the Canadian context and abroad, we've seen increased problems with health, increased problems with personal security, increased problems with maintaining and enjoying one's culture and one's land and preserving the environment. We have seen gross human rights violations, but in turn, we also see increased unified action by Indigenous peoples, the exercise of their rights, the protection of their territories, and with that, increased business risk, increased or decreased shareholder confidence. So it begins to start to affect Indigenous rights, and the exercise of their rights start to affect the global economy and the investment system. So another opportunity emerges, which First Peoples Worldwide in their, and Rebecca Adamson is the director of that in her risk report, is beginning to see the interaction of the exercise of Indigenous rights and the vulnerability of corporations. This may be, in fact, why we're seeing more leadership, more understanding, more sensitivity, I will call it, but more motivation of industries to attend to understand, and to begin to find business practices in accordance with UNDRIP and the principles of free, prior, and informed consent. An example of that, the contradiction would be the Canadian government saying that they do not support FPIC. On the other hand, we see the International Council of Mining and Minerals, which has many Canadian corporations and gold companies, mining industries within it, saying that by this spring, 2015, they must be in compliance with FPIC, and that there are problems with that document. They have watered it down, but you can see industry leadership in trying to understand the new world context of an Indigenous rights regime and the necessity to reduce business risks, to increase shareholder confidence, and to work within the frame of the global principles of the UN of business and corporate social responsibility, to begin to work in adherence to a new model of business. Nevertheless, we have conflicts, and that conflict will not allow peace, will not allow prosperity. How can we move to increase peace and prosperity? We will, government and industry can be confident that the examples in New Brunswick here in Canada of fracking demonstrations, Indigenous peoples asserting their rights around their land and territories, demonstrations on the Alberta oil fields and the tar sands, the BC pipeline demonstrations and the resistance, the Ontario Ring of Fire, where we saw major corporations move away from the table because they thought it was too difficult, because they don't yet know how to engage in a consultation process, and governments haven't prepared the ground adequately. We see in Chile where a Canadian company, I think it was Barrick Gold, shut down their operations at great expense to them because Indigenous peoples were resisting, and because of a company's violation of non-compliance to their agreements on environmental issues, and the communities closed them down. They are coming back to the table apparently, and they're working on trying to establish more authentic consultation with the communities, and going in with free, prior, and informed consent now with a new model working relationship that has really been pushed by the communities and had to be attended to by a company as huge and as powerful and as wealthy as Barrick Gold. I heard them speaking just recently at PADAC, at the convention in Toronto, members of Barrick Gold talking about how they are coming back to the table with a new sensitivity, a new understanding, new sensitivity, but they're highly motivated as industry. Indigenous leaders such as Chief Wilfrid had said that we can't fight with guns, that in Canada the Indigenous people are a majority, but they are a force to be reckoned with, and they will increasingly stand together, and hopefully Canadians will stand together with them around their rights. So we have an opportunity in the two-row wampum. We have an opportunity in the past. Is peace possible? In the past, we saw that Indigenous peoples were working together with settler populations. We had an agreement of peace, friendship, and trust. We could go back to that, of working together side by side toward a common goal. Our common goal in the past was to be working on shared mutual benefit. We have an opportunity once again to work within an Indigenous rights framework where we have mutual benefits for mutual prosperity that's working within the guides of free, prior, and informed consent. Thanks, Andrew.
Thanks so much, Terry. And as I'm sure many in the audience will have picked up, there's a strong Canadian theme to this discussion. And so our last speaker is Bernard Taylor, the Executive Director of Partnership Africa Canada. So over to you, Bernard.
Thanks very much, Andrew. I'll be speaking from a slightly different angle. I won't be speaking so much about the question of individual human rights. It'll be more to look at different forms of conflict, including armed conflict, in Africa, and particularly in Central Africa. First of all, a quick word about Partnership Africa-Canada. We're a research, policy, advocacy work organization founded some 30 years ago. In the late 1990s, we began looking at conflict in Africa and what were some of the causes of that conflict. And you referred to us being the first organization to point to the problem of conflict diamonds, Andrew, in your introduction. We were actually the second. Global Witness began working on the war in Angola and the link with diamonds a little while before us. We were working separately on the war in Sierra Leone and the obvious link to the diamond trade there. But we began working together the following year in 2000 when something called the Kimberley process for conflict diamonds was instituted in South Africa. We continue working in that process today to help regulate the rough diamond trade, to break the link with conflict there. And in relation to that, I'll say a few more words about the work that we're doing in different areas. In relation to that, we're trying to work in West Africa to achieve a regional approach to this as opposed to a country-by-country approach, because as you can imagine, diamonds are smuggled across borders and that leads to instability. Following on from that work, we became involved in efforts in the Great Lakes region to create a system to regulate conflict minerals in that region, the so-called 3 Ts. That's to say tin, tantalum or coltan, tungsten, and gold. And we helped develop a regional certification mechanism for those minerals, which is being implemented now. We're working in some projects in the Great Lakes region on particular minerals such as gold, to break the links with conflict. We're working on the role of women so that they are more involved and also protected. And at the international level, we're working on the question of transparency and the mandatory disclosure of payments made to governments by industry. Let me focus on 3 aspects of our work in the Great Lakes region. You'll be aware of the conflict, the armed conflict, the war, or the wars that was happening there in the late 1990s and the early 2000s. Well, you know, efforts to deal with that led to our work, let's say, in support of a regulation of the minerals flowing in that region, which are directly linked to the armed conflict there. An armed conflict which was cross-frontier, where you had armies of different countries involved, Uganda, Rwanda, Burundi, DRC, and other countries, which, of course, has subsided since then. However, in Eastern DRC, there are still many armed groups, a dozen or so, which sort of come and go, become weaker, become stronger as things develop. The efforts to regulate the conflict minerals from those regions, efforts which have been brought about by the Dodd-Frank legislation in the US in 2010, by the OECD due diligence guidance for responsible supply chains of minerals from conflict-affected areas, that's also dates from 2010. We helped develop for the countries of the region to monitor and to certify minerals. All that has had a positive impact. Let me just give you an example. The 3 Ts, the tin, tungsten, and tantalum, the certified minerals from mining areas, and it's artisanal mining, I should add. The price for those minerals is higher than minerals which are coming from areas which are perhaps controlled by some armed groups. So there's an economic pressure now being put on those armed groups. There is a problem in the process is rolling out slowly. So there are some regions where artisanal miners are not yet covered by this system, and so they may be receiving less for their work, for their produce. But as things continue, with luck, we hope the whole region will be covered by these programs.
Bernard,
yes.
I'm sorry. A number of our viewers have lost the video. Could you refresh your browser? Sorry, a number of our viewers have lost the video connection. Could you refresh your browser?
Doing so now.
Okay, thank you. Sorry about that. And apologies to our audience for the technical difficulties. Hi, everyone. While we try and reconnect Bernard, we thought we might just go right into the open discussion. And so if any of you who have been listening have questions for Tara or Terry, or for both of them, please feel free to post them to the questions and suggestions page, and we'll get started with the discussion. And maybe I'll start while we're waiting for people to submit their questions. And Tara, what has the reaction been to the amnesty report, either by the extractive companies who are named in it, or the Canadian government, or the Guatemalan government?
Great, thanks for your question. As with all of our research reports, before we publish the reports, we share the results of our findings with the companies that we've investigated. So all of the companies named in our report had a chance to review and comment. And where appropriate and where their information could be corroborated by our research, or et cetera, we would maybe include some of their changes. Or some of their additional information. But we presented the report to the Canadian government in November, and there are several departments there, and unfortunately there's such a high level of turnover within the various corporate social responsibility departments, foreign affairs, and so on, that most of the people that we met with had been on the job maybe 2 weeks. So there wasn't a great deal of response other than "thank you, I'll read it." But we always intended the Guatemala research to be a case study to push the Canadian government to respond the way that we think they should with mandatory legislation, more than what we have now. In the case of Guatemala, it was very interesting. We held a press conference the last day that we were there, and it was standing room only in the salon where we held the press conference, and we were told that there had not been such interest in an issue since the Rios Montt genocide trial the previous year. So there was a great deal of interest in Amnesty's findings. We had community members travel from throughout the country, from very isolated communities, to come and to be there to support the publication of the report. So that was good. We also met with the Ministry of Energy and Mines to present the findings, and the CACIF, the business, the industry organization. And they were very concerned with the findings of the report, and concerned with what the impact would be on investors. There's a lot of, passing the buck, I would say. Well, our department can't regulate consultation; it's up to another department. And it's very clear that the Ministry of Energy and Mines is under-resourced, has largely left it up to companies to decide what to do around consultation. There's no guidance. The Guatemalan president in 2013 did call on Congress to establish a moratorium on granting new mining licenses. They haven't. And there was also a regulatory reform package that was put before Congress. And the hearings actually wrapped up the week that we were there, but Congress hasn't reported on them at all. It's an election year in Guatemala this year, so it's kind of like I guess what they call a lame duck year. We don't expect to see much happen, unfortunately.
Right.
Yeah.
Okay, we have 3 questions that have come in, and I'll ask them all at once. And Terry, I'll get you to respond first, but Tara, please weigh in. First question is, Terry, what do you think about Aboriginal people partnering with extractive industries in Canada? The second question is, lots of examples of bad practice here. Do any companies or states manage to balance resource extraction with actual contributions to peace building? And then finally, how would you both rate the efforts of global mining companies in advancing corporate social responsibility policies and approaches? So Terry, why don't you start, and then we'll go to Tara.
Okay, thank you. Well, I know there's controversy even amongst Indigenous populations themselves about who's doing what and how it should move forward, and what is an individual action, what is a community action. Most of the rights we're talking about here are collective rights, and territorial, political, and cultural rights are at a collective level. But of course, individuals will make, like the rest of us as settlers, will make individual decisions within our own frameworks. However, what I do see, even in a critical framework of partnering between corporations and Indigenous peoples, there's 2 that we see. One is an agreement between a corporation and a community to move forward to develop resources in a particular way. If that's happening with free, prior, and informed consent, I think there can be tremendous benefit for communities, tremendous benefit, financial and otherwise, to have control of their territories, to have the opportunity to generate wealth, which a self-determined development, as I was speaking about, and it can relate to the funding of self-governance, where Indigenous people will have an opportunity to fund their healthcare, to fund their education, to fund their housing and their employment, and to create the infrastructure that they wish for their lives, and not be dependent on the Canadian government or other governments upon their programming. Not to say that they shouldn't still be keeping their treaty rights and their fiscal responsibilities under the Constitution and other agreements that First Nations have. So that is my thought, is that self-determined development, where individual communities and nations are working with corporations to develop agreements that are based on active participation and consensual agreements around the whether development will happen or not, the nature of that development, and well-negotiated resource revenue sharing benefits can be tremendously positive for both the society, for the industry, for the government, and for the Indigenous nations.
Tara, do you have anything to
add? Yeah, I mean, I echo and appreciate what Terry is saying. I think also in Guatemala, what we've heard, and again, I'm referring to kind of a very a single context. But what we've heard from communities on one hand, and this is more in, I would say, the predominantly non-Indigenous communities, is that they would be open to the idea of considering extractive industries in their territory or in their community if there had been, a thorough and meaningful consultation process, and if they had been brought in as very equal partners at the table with a say about what happens in their communities and how to mitigate the risks, that there would have been an openness to that and potentially to enjoying some of the benefits. But it's a little bit of, putting the cart before the horse in some of those communities where you have companies that have kind of a CSR plan, a corporate social responsibility plan, and they've got their tick boxes. They're going to do schools, they're going to do a medical clinic, etc. And communities will resent, mining companies going into their elementary schools and offering school supplies because they feel it's taking advantage of people's poverty and offering their kids, trying to get access to consent through and a social license to operate through the children. So you see some resistance there where people feel like they haven't had a meaningful conversation first to be able to determine if they want to work in partnership. And in other regions of the country, the Western Peoples Council of the Highlands, which is an organization which the Western Indigenous Mayan communities belong to, have just said flat out, no, mining is not within our cosmovision, and we are opposed on every level. And, it's up to the state to deliver those programs, not up to companies. And so that's where the tension lies, where, companies may, and this responds a little bit to another question, companies may have a very good, well-meaning, well-funded CSR program where people working in those departments really believe that they are helping fill the gaps left by the government. They're providing services, they're giving something back to the community, and that intent is genuine. But the question always remains for those communities, what happens to those projects when the company closes shop? There's a hospital, but where are the medicines? Where are the physicians? Where are the nurses? So it's a lot more complicated than it's presented as. And so there's no doubt that there is conflict that arises through those initiatives.
So we have Bernard back, and Bernard, I wonder, sorry that we lost you earlier. One of the questions that was just asked was about whether or not there are examples of best practices, whether at the state level or companies that are genuinely trying to make real contributions to peace building. And I wonder if in your own experiences you've encountered some of these cases that could perhaps be modeled elsewhere.
In my presentation, I began talking about work around conflict diamonds and conflict minerals in the Great Lakes region. In both cases, I would say that at one level, companies have been very positive in their work. In the case of diamonds, for example, you've got major companies like De Beers that work very hard for what became the Kimberley process to be established. Why did they do so? Because it was in everyone's interest, including their own business plan. So, if whatever is being discussed makes good business sense for a company, for a country eventually, for a community, obviously each case will be different, then I think you have to go looking for those commonalities. Let me just give you another recent example very close to home. A few years ago, when an organization which is based in our organization, Publish What You Pay Canada, was lobbying for the question of mandatory disclosure of payments made by mining oil and gas companies to governments throughout the world. The government in Canada wasn't too enthusiastic, and one of the reasons was given was that the industry, the mining companies, etc., are not that interested. Well, we began to work separately with the Mining Associations of Canada, with MAC, the Mining Association of Canada, and with PDAC, in a process of dialogue which led to a final position where everyone agreed on a way forward. And this coincided, in fact, with efforts in the G8 led by the UK to promote transparency. And the Government of Canada saw a way of moving forward, inspired by this civil society industry dialogue, and a couple of years ago announced that it would institute mandatory disclosure, which is a huge step forward. And it's being implemented now. I mean, it's being finalized now. So I just cite that as an example of where you may be, facing a brick wall. But if you can get the right people together, there are ways forward. But obviously, each situation is different. Each case is different.
Right.
So those are a couple of very positive examples.
Another round of questions, and I have one for each of you. Terry, are you aware of any success stories, perhaps in the Canadian context, of government, private sector, and Indigenous communities working together to a successful outcome? Are there specific examples? Tara, for you, we have a question about whether or not farmers in Guatemala have tried to come together to form an association to challenge mining regulations, whether there's been collective activism around that. And then the final question for this round is, and perhaps Bernard, you're best placed to answer this one, is whether or not we have anything like a code of conduct for the extractive mining sector. And I know there have been many attempts at this. And so where are we on that particular question? So Terry, I'll start with you and then go to Tara and then Bernard.
Okay, unfortunately, I'm not really knowledgeable about this, and it is an area of my interest. We have looked at a number of examples. I think that Indigenous communities who have developed their own economic development plans, there are several in Canada that have been very, very successful, where they maintain control of their territory and they maintain control of their business, whether it's environmental ecological tourism or whether they have their own fishing industries, and lumbering. They may have their own programs that they maintain control over, and they've been successful at those and generated great wealth for their communities. There are also communities that have been leaders in establishing appropriate, we could say, free, prior, and informed consent for development, where they've negotiated very wise business agreements on resource revenue sharing and have developed parallel businesses in keeping with those. However, some of those examples are in the extractive industries in our tar sands area, where the community, the chief of that community, negotiated very, very well for parallel businesses so that their community became wealthy. But that negotiation didn't happen within the framework of their cosmovision and their ontological differences around preserving the environment and preserving culture, and it has had tremendous health impacts for them, social impacts, and now when they're saying no to industry for expansion onto further areas of their territory, the courts are siding with the industry, even though they've been great business partners. So there are good economic models of partnering, but they weren't framed with cultural frameworks. So I think in answer to the earlier question, that's part of the good business arrangements. They will come in the future when we understand that there are two world visions and that we have to respect the Indigenous perspective. So one of the models going forward, where we see industry has walked away from the potential wealth, is in Matawa nations, where the 9 Matawa chiefs are working together, have organized to develop a regional development framework. And in that framework, you will see the 4 directions, and you will see the medicine wheel, and you will see their attention to environment and to culture and to community. You will see that they don't intend to go forward to access the resources the chromite out of the $55 billion of chromite out of their land, unless they can maintain their cosmological vision of the environment, the people, and all of their relations, meaning their water, their land, the trees, that they maintain their understanding and a commitment to future generations. That, as Tara said, that giving notebooks in schools or building roads or offering jobs will not be enough in terms of their wisdom about going forward for 7 generations. So while I don't know enough about them, there are good models, and I think we'll see more and more going forward now that we have strong rights frameworks.
Thanks, Jay. Tara.
Yeah, on the question around the Guatemalan farmers, in that particular area, I'm talking about the community of San Rafael Las Flores, which is near the Tahoe Resources silver mine, the Escobal project, which is subject of a civil lawsuit here in Canada. So community members, which are predominantly farmers in that area, did launch a legal challenge to the company for pollution in the exploration phase. And I believe the court did rule that there was pollution and there were some fines, but I don't remember all the details of that. I can follow that up with Andrew later. But in the bigger picture, there has been a constitutional challenge to the mining law. So CALIS, which is a Center for Legal and Environmental Action, which works with a lot of mining affected communities, did challenge the current mining regulation, and the Constitutional Court found that 7 articles of the mining law were in fact unconstitutional and made a number of recommendations. And then in 2012, there was a further ruling on that. However, despite the Constitutional Court ruling that several articles of the mining law are unconstitutional, the government has continued to issue exploration and exploitation licenses. So, again, it's we've seen it in the States, we've seen it in Canada, what the judicial branch rules, the executive branch doesn't want to implement, and this is the tension that exists.
Right. Bernard, if you could say something about a code of conduct, and there's a follow-up or an addition to the question, if you could also perhaps give an update on where things stand with the Kimberley process.
Okay. Let me give you the example of the OECD due diligence guidance for responsible supply chains of minerals from conflict-affected and high-risk areas. Sorry, it's a bit of a mouthful, but it's the voluntary guidance that was developed in the OECD, and civil society organizations were part of that dialogue with different companies. And the net effect of that, it complements what is being asked for by the Dodd-Frank legislation in the States and the regional certification systems that I mentioned in the Great Lakes region. What that is, the impact of that is that increasingly, and I use the word increasingly on purpose, those end user companies, whether they be Apple or Intel or Motorola, etc., that are using, that are finally importing high value minerals for IT products, etc., they are putting pressure right down the line on their suppliers, on the the companies, the smelters in Southeast Asia, in China, in Eastern Europe, and in various places, to make sure that they source their minerals in a responsible way, i.e. from certified mines, etc., etc. And that's back down the road, that's having an impact on the ground in Eastern DRC that I mentioned earlier. And I can give you related 1 or 2 related examples of that. What I didn't mention earlier was that the one high value mineral which is being used by armed groups in Eastern DRC is gold at the moment. It's very difficult because it's very easy to carry, it's very difficult to manage. And a lot of that gold, most of it is mined artisanally in DRC. Most of that is exported illegally to places like Dubai. Now, not so long ago, representatives of the jewelry industry from the West, from Europe, from the States, went to Dubai and said, you've got to clean up your act. Otherwise, we may not be buying the sort of gold that we've been buying in the past. And that pressure is now beginning to work on Dubai. The authorities there are strengthening their regulations. Of course, the proof will be, will be seen later on. But I give it as an example of the pressure building up, and it starts here in a way from consumers that ask questions about, where did the gold come from? Where do these diamonds come from? That is very, very useful. And Amnesty, of course, has done a lot of work in North America on this in the past. Maybe that brings me on to the Kimberley process. You can help establish and you can help manage, as we are doing, international regulatory systems like that. Some say they're 99% perfect. We would say maybe they're 80% perfect or 75%. It's covering and regulating the majority of the rough diamonds in the world. But there are always those situations where some production goes through the back door, and it's not 100% tight, for certain. But obviously it's a lot better than it was 10, 15 years ago when the Angola War was being fought on one side by oil, on the other side by diamonds. And in Sierra Leone, the death and destruction that we saw, in the film Blood Diamond, that was being caused by the diamond trade. So it's far from being perfect. We're trying with others to make it better, but it is a lot better than. All
right, we have another question for you, Bernard. It's
because of that.
Do you know any examples of complicity of mining companies operating in Africa? And perhaps I'll offer a follow-up to the question for all of the panelists, and that's the question of corruption and how that factors into some of these business arrangements and the human rights violations. So, Bernard.
Interesting question. I'm sure there are a lot of examples. I'm not a great source of those examples. There was a time a couple of years ago when we did quite a lot of work on the situation in Zimbabwe, where the diamond mining trade there was being dominated by a few companies, but where the authorities in Zimbabwe were also involved. That's to say that the government, leading generals in the army, leading politicians, they were hand in glove with the few companies that were working there, including one company which was run by Chinese military. So you have some extreme examples like that we could mention, and we did research on, and we did publicly reported on that. There are some governments that perhaps are too close to those sort of situations. We've mentioned problems with the UAE, with Dubai, in their sourcing practices. That's applied to gold. It's applied to diamonds as well. But as for corruption, I think that's a very big issue. Where you have better governance in a country, you tend to have less corruption. But even in such advanced countries such as South Africa, the government needs to tighten up on how politicians and influential business people are involved in mining, whether it's in South Africa, whether it's in Zimbabwe, whether it's in the Central African Republic. There are lots of connections that are occurring, and institutions in some of these countries are just not strong enough.
Any thoughts on questions of corruption?
Well, I just can say that the UN Global Compact, it kind of relates to the question about our companies self-regulating, our industries regulating. So one of the things is the UN Global Compact, which has 7 principles in 3 areas under human rights, environmental sustainability, and corporate anti-corruption. So they are looking at that, but they're not specifically on the extractive industries. But of course, many of those countries, most of those companies actually are extractives. There's also the ICMM, which I mentioned, on the International Council of Mining and Minerals. They have kind of self-regulations about anti-corruption, but in both of those cases, they prefer and they continue to work in voluntary compliance.
And in Guatemala, again, in some of the mining affected communities that we visited, people have said, yes, corruption is an issue, but you have to recognize that in many of our communities, we operate and we're accustomed to operating on a more of a subsistence level. So we don't have the structures or the cultural practice in place to manage, millions of quetzales or whatever the currency may be. And so it's very difficult. I know in one area of Guatemala, Goldcorp has talked about working with municipal governments to try and set up systems to be able to manage royalties and to deal with corruption issues, but it's a challenge because the needs are so great as well. But there's not that, in some cases, that historical experience with dealing with that vast volume of money. So that's been flagged to us as a challenge in terms of corruption.
And what about consumers? I mean, one of the things about the blood diamonds issue is that it's very tangible to every average Canadians or average North Americans, whereas some of the other minerals, things, coltan appears in our electronic devices. It's not as much in the consumer consciousness. Are there efforts to essentially launch consumer awareness campaigns that would then in turn lead to greater pressure on companies and states to extract minerals in a responsible way?
Regarding those minerals, yes, there are efforts. I think they're quite developed in the US, which of course where the first legislation, the Dodd-Frank legislation, came up. I think they're particularly strong at the college level, the university level in the US. But in Canada, there's a campaign, the Conflict Minerals campaign, which has been going for a couple of years. And you're probably aware that there was there was legislation tabled in the House of Commons on this, particularly referring to Central Africa. The legislation didn't pass, but I mean, it raised awareness at parliamentary level, and separately this campaign, at the university college level, raised awareness. And I think, if you make a link between this subject here, the cell phone, and what's happening in Eastern DRC, the conflict there, the armed conflict, the suffering of communities, the particular horrendous things that are happening to women in Eastern DRC. If you make that direct link publicly, I think a lot of people will understand and sympathize and voice their opinions. So there is an effort being made, but obviously it needs to be increased. And let me just add that and it's not just through the companies I think we have to act. The fact that there are in Eastern DRC so many armed groups still operating, it means that they are being supported in some way by a neighboring country or by influential people in DRC, military, for example. And I think that's where our governments can play a role. Our government may have a strong relationship with, say, with Rwanda, but not with another country. And the same for Britain, the US, they have to put pressure on those countries to withdraw their support from armed groups to achieve regional stability, and then and then we can really get to peace in that particular part of the world.
Terry, there's a question for you, and that is, are you aware of any tangible impacts of the UN Declaration on the Rights of Indigenous Peoples?
Well, it depends, I guess, how I might define tangible. But I would say tangibly, yes, I know at least of one. But in Bolivia, the UN Declaration has become embedded into the constitution of their country. So Evo Morales has taken that up to say that this is an international standard and it will be a domestic standard. So that's kind of leadership for the rest of the world. And we've seen that happen in a number of South American countries where they are moving closer and closer to actually ratifying the declaration in a sense that it becomes a legal document within their own domestic setting. So that's a great model for us. In Canada, what we see is the declaration, while silenced by the government, has been a tremendous, and I will say tangible in this sense, symbol of hope and recognition at in an international context for people in their small communities and their larger communities domestically and around the world. Means that they are no longer, and their trials and their history is no longer invisible, that it has been validated, the oppression has been validated, and the opportunity to go forward with their political, cultural, and territorial rights recognized by an international body is a huge source of hope and a basis for momentum and unified action, such as we saw in Idle No More here in Canada. We also see that with the declaration that it's bringing, it's a focus point after 30 years of development by Indigenous people from around the world and their leadership. It's a focus of discussion and dialogue. So I think tangibly that the outcome document that came out of the World Council of Indigenous Peoples this fall, where they said that they should move now to implementation at domestic levels, that countries should be held accountable to now implement the declaration, and they would be participating in that. I think that that's moving towards seeing tangible, unified international efforts. The other is that we have now, coming out of the declaration, the position by the UN of the Special Rapporteur on Indigenous Rights, who travels with James Anaya, and now I can't remember, it's Victoria. Do you know her name, Tara? I can't hear. So Victoria. Yes. I can't think of her name right now.
Oh, you can hear me. I think it's Victoria Corpus-Tally.
Yes,
no?
Victoria Corpus-Tally. So we have the UN Special Rapporteur, who is a witness, an international witness, who goes and spends particular periods of time in countries talking with Indigenous people and leaders and their governments to hold them accountable in the sense of being having a witness. So I think that's a very tangible output of meetings that have resulted in the declaration, that we now have ongoing international witnesses to the Indigenous rights violations, as well as the advances that are being made by people.
Okay, I've got another round of questions. One is from a gentleman who asks why, especially in the African context, why there is so much Western complicity and why the UN and even groups like Amnesty International haven't been able to be more effective in some of these contexts. Then we have a second question for you, Tara, and that's whether or not you're aware of solutions that have been put on the table that have yet to be implemented, but perhaps if implemented could make a real difference in moving this issue forward.
So the first question on why the Western complicity and interest, and why the UN has been...
Yeah, Bernard, if you'd like to take a stab at that one.
Yeah. Okay. Sure. mean, there's a whole history of colonialism and political, geopolitical interests that run across the world. And we see it currently in the Middle East and elsewhere, and of course Africa is no exception to that. But if I look again, I focused on Central Africa in my remarks today. If I look back on that, the actual peace process starting in 2003 was coordinated by the UN, and it received backing of countries in the region, but also Western countries, including Canada, which was very active in support of that process. So the peace process, which is still struggling because of the localized conflict which is occurring there, it's not yet cemented as it should be. It did receive strong coordination from the UN. But the bigger picture that's being referred to in that question is the interests, the geopolitical interests that are pervasive throughout the world, and that's a real international issue that needs to be resolved. And of course, Africa is not
on the second question.
Yeah. Are you aware of any solutions that have yet to be implemented?
That's a big question. There are some examples of bills. Just recently, France and Switzerland heard bills on corporate accountability that had been put forward by their civil societies that looked at due diligence and corporate accountability for French or Swiss companies' overseas operations. Both those bills were, I believe, they were defeated or referred back for amendments, and there's a lot of fear that those will be, the provisions will be weakened. But that's quite recent, in the last month or so. In Canada, we had a very good opportunity to move this forward, and there were some excellent suggestions on the table. In 2005, the government, the Foreign Affairs Committee, Standing Committee on Foreign Affairs and International Trade, had heard horror story after horror story of Canadian corporate complicity in human rights violations around the world. And so they established an industry, civil society, and government task force, referred to as the roundtables, the CSR roundtables, to kind of investigate together these stories and to come up with a way forward. And so in 2007, and I did send a link to this document on the chat panel there, industry and civil society tabled a joint report that came up with a series of recommendations about how Canada could deal with this issue. It was a groundbreaking report. It had consensus, and it really would have moved things forward. It took the government about 18 months to respond, and when they finally did, their response was their corporate social responsibility strategy, which includes the, what is seen as largely a failed corporate social responsibility counselor's office, which was mandated to mediate between companies and communities in situations of conflict, only with the agreement of the parties. So if a community came forward and said, we have a conflict, we have an issue, and the company said, nah, we don't want to participate, end of story. The office has been quite unsuccessful. They did recently hire, after a 2-year gap, a new CSR counselor at Industry Insider, but that was a lost opportunity there. Now, and the government just came out with an updated strategy. It's got a little bit more bite to it, but there has been a national response to that amongst civil society organizations, unions, churches, NGOs, and so on, academics as well, through a campaign called Open for Justice. And so we've kind of taken this beautiful industry, civil society, agreed upon way forward, and we've broken it down into pieces, which focus on requiring the government, asking the government to set up an ombudsperson's office that would be tasked with looking at extractive sector cases, but would have some power to make recommendations, suggest sanctions, and to report publicly. And the coalition is also asking for access to justice in Canada for foreign victims of corporate crime. So, for example, it's very, very difficult and multiple barriers in Canada to victims being able to access justice through courts. And so one of the ways that companies are able to kind of block that is to argue forum non-conveniens, which basically means Canada is not the right place to hear this case. And so there have been successful attempts on the part of companies to have cases referred back to the jurisdiction where the crime was committed or alleged to have been committed, and then those victims never see justice. So one step could be to deal with the forum question by legislating access to Canadian courts. So there are good proposals on the table, very incremental in Canada right now, but we know that in this moment, this government is not going to move forward on them, unfortunately.
Great. Well, we have just a few minutes before our session's over. And what I'd like to do is just ask each of you to say, one thing they'd like our audience to take away from this discussion. And before we do that, Tara, we just have a question. If you could mention the name of the coalition again to our audience. So
it's the Canadian Network on Corporate Accountability. Oh, sorry.
Great. All right, so we'll go around in the same order that we presented. So Tara, Terry, and Bernard, one thing you'd like our audience to take away from this discussion.
I hate going first. I guess I would ask people to one of the things that we often do with members when we talk about this massive issue, which is very complex and depressing often, is to ask people to do two things. One is to look at on a personal level, your own involvement in supporting Canadian companies overseas. So looking at your investments, your mutual funds, your RSPs, and really asking questions of your bank or your investment advisor about the human rights practices of the companies that you're invested in. We're all invested in many of these companies through our contributions to CPP, but we think that there is an opportunity to put some pressure on the CPP and other pension funds. But also, I think on a broader scale, to think about and reflect on the communities and the people who are daily living under this constant pressure of criminalization, of threats, of harassment, of needing police protection for things that we use as consumer products here, cell phones, jewelry, and just to think about that personal connection. We think that's really important. Of course, we'd love you to take part in all of our campaigns and collective work to establish corporate accountability mechanisms in Canada. We think that's crucial moving forward.
Great, thanks so much, Terry.
Okay, hi. So what I want us to take away from this is to remember that, as John Ralston Saul has trying to remind us in Canada, that we started with 300 years of peace in this country between Indigenous peoples and non-Indigenous peoples, and that we had shared a mutual benefit in our relationship, whether it was military or whether it was through the fur trade. But we saw each other as allies, and I was mentioning before about the two-row wampum, and we said that we would work together side by side without interfering with one another. And that two-row wampum is a treaty of peace and friendship, which is based on the principle that we have two worldviews, and that they're both legitimate, and we have two different lifestyles, and that they're both legitimate, and that they could coexist, and that we could coexist. But we broke that treaty of friendship. And now there's another opportunity where we can see that we are actually dependent on Indigenous peoples, that we need them. We need the land that they're on, because they're on the land where the resources are that we want, and we have displaced them from that land. So what I'd like us to go back to is remember that they're not the problem, that they are the solution, that they have power, and that they have the privilege of being the word is, I can't think of the word, is to take care of the land, that they are caregivers of the
Stewards.
pardon? Yes,
Sorry,
that they have, they're
stewards.
stewards of the
No,
land,
maybe?
and that if we're going to, we need the land, we need the air, the water, and that we can be partners again in the way that we were in the beginning, to partner together to understand the land, to understand sustainable environmental, ecological well-being, and within that to understand how resource extraction and other industries fit for sustainable development. And that if we do that with understanding and respecting the two worldviews, we will be able to achieve self-determined self-development, which means that we're not only have Indigenous peoples as partners, but we really could rebuild our friendship to understand that we can coexist within our different world frames, and we will all be the richer for that. Without that, we will have no peace.
Bernard.
Good. The disadvantage of being last is that a lot of the good things have been said before you. Let me just add that one or two things we've learned in the last few years has been the importance of dialogue, in that, yes, you have polarized situations. Sometimes you may not be talking about the same thing. When you say the word conflict, are we talking about disputes over land, accession to land, or are we talking about armed conflict, which is, another version of war? So I think, the language is important, ideas are important, and it may well be that more sustained dialogue, searching for commonalities, for, common ground, if you like, can be very productive. We found that in several situations. And it's because of that that we place a special emphasis on working with civil society organizations in Africa and trying to help them and together improve our understanding of situations, strengthen our capacity to understand how the mineral trade works, the origins of conflict, etc., etc. So that would be my parting thought. Let's improve our understanding of situations and at the same time encourage more sustained dialogue.
We are over time, and I know that we could have keep going on and on. Tara, Terry, and Bernard, this has been absolutely enlightening. Thank you so much, and thank you for taking time out of your busy schedules to be with us, and best of luck with your continued work.
Thank you.
Take care.
Thank
Very
you.
much.
I have to say that with my romantic...
Thank you. All right.